Good afternoon to all of you, our cherished viewers, and welcome to Hot Issues. So the Progressive People's Party has been cleared by the court, or, well, they've directed the Electoral Commission to actually give them a chance to correct errors they made in filling out their presidential nomination forms. What did the court actually say? And what were the reliefs being sought by the presidential candidate of the Progressive People's Party, Dr. Papa Kwesi Ndum? And what does this mean for the other cases in court, as well as what does it mean for the presidential elections come December 7, 2016? This afternoon on Hot Issues, we're discussing the implications of the ruling by the court yesterday. The guest this afternoon is the lead counsel of the Progressive People's Party during this particular court case, former Attorney General and Minister of Justice, Honorable Ayikoi Otoo. Good afternoon, and thank you very much for joining. And let me say congratulations to you. I'm sure that's a pleasant feeling that you've gone to court and you were successful in having the court do the right thing. But I would want to understand something first and foremost. What were the reliefs that you sought from the court?
Well, thank you. Let's say that we take some of these things in our stride, and it is necessary for some people out there to know that we've been around for some time. We are not very young persons or young practitioners who will be taken away, just because of one case. We've done a few cases. Having said that, there are grounds for an application to court, what we call certiorari, or generally when we refer to prerogative writs, we're looking at certiorari, mandamus, prohibition, things like that. The ground is that if there is a breach of the rules of natural justice, that there's error of law apparent on the face of the record, there's excess of jurisdiction or lack of jurisdiction, and these days what we call the Wednesbury rules, where the officials have acted in a manner that can be described as being irrational, illegal, and have been fraught also with procedural irregularities. So your duty as a lawyer is to listen to the facts that will be presented to you by your client, and then ask yourself whether it falls within any of the grounds. Now, having listened to Dr. Papa Kwesi Ndum, I felt that a certiorari would be the best approach. So the relief was to ensure that the decision to, disqualify him is quashed, and then he is given the opportunity in terms of the law to make the necessary, amendments and alterations, and then these forms are now received by the returning officer, who is the chairperson of the YEC, because in presidential elections, the chairperson of the YEC is the returning officer, and then we take it from there. So these are the reliefs he sought, and he got them. The other one, which the judge didn't speak about, but then it's obvious that it flows from what he has said, was a prohibition that she should not proceed, or the commission should not proceed with balloting for presidential positions, on the ballot. And that one, if we are going to start the process all over again, it only makes sense that you will not go ahead and ballot.
So that one wasn't granted, but from...
No. It was unnecessary, as it were. Because once the decision has been quashed, and the commission has been asked to grant you the opportunity, then it's like you haven't finished the nomination side so as to move on to what you call the balloting for positions. So in any case, it won't come on, and she has never done that since we went to court. So I think it's not this, but I'm solely saying so to you because it was part of the reliefs that we asked, since you wanted to know what the reliefs we were seeking.
Now that we've established the reliefs that you sought from the court granted it. But looking at the ruling of the judge, one, you went by face of by the fact that the principles of natural justice had been breached, and also the fact that there were some errors. Now the judge was very explicit in the breach of natural justice by saying that you should have been given a chance to do so. But the Electoral Commission actually challenged that. Now they felt that one, your clients didn't submit it earlier, and to the fact that they were not supposed to be responsible for the mistakes that your client makes.
you see, they got the wrong end of the stick. And that's why I believe that some of these things, when you rush in discussing them earlier than when you've seen the entire, evidence, to me is not the best. Because some people might not have even seen the law dealing with the public elections.
Okay.
And yet they were making comments and creating the impression that like all those who were disqualified are criminals. Or
So where did
hold on, I'm coming. They are criminals, and that if they have had it, so be it. But let's read the law and the regulations. This is the Public Election Regulations 9, which is more germane to the issues we are discussing. 9.1. Whenever the nomination paper and the statutory declaration of a candidate are delivered and the deposit is paid in accordance with these regulations, the candidate shall be considered to stand nominated unless proof is given to the satisfaction of the returning officer of the candidate's death, withdrawal, or disqualification. So Papa Kwesi Indum comes there on a particular day. He gives you his nomination forms, statutory declaration, pays a deposit. He's a nominated candidate. How do you disqualify him? Because if he's not dead and he has not withdrawn, then he ought to be disqualified. So that's the next thing. The returning officer shall inform a candidate that the candidate's nomination is invalid, where A, the particulars of the candidate or the person subscribing to a nomination paper are not as required by law, or B, the nomination paper is not subscribed to as required by law. Ask yourself, what is the meaning of as required by law? It means that whatever you have done has gone against the law. Because you did not do them as required by law.
And in this case, they say they didn't do them as required by law.
Yes, that is what they said,
Yes.
as required by law. That's all right. Then what are you to do? They shall now give the candidate an opportunity to make amendments or any alteration necessary within the stipulated nomination period. On whom is the duty cast? Is it not on the returning officer? And they chose the word shall. They didn't say may. He said you shall give the candidate an opportunity to make amendments or any alteration necessary within the stipulated nomination period. So what is this talk about? Share responsibility, something on me, something. Where is it coming from? Whose idea is that? Who is misleading who?
Now
who is giving that? No, let me land. I want people to understand, that the duty is cast on you. It is not a discretion that you may maybe ask the guy to see if he can do amendments or alteration. He said you shall give the candidate, afford him an opportunity to do the amendments and alterations. These words are also very critical. What is an amendment? This evening, I've been sitting back in my office and, after the judgment, I sat in my office and I heard a whole lot of things that people were saying without regard to the meaning of the word amendment.
What things were people saying?
Amendment. No, please, hold on. How come there? Amendments and alterations. If you ask someone to amend, he is to do something to the whatever is there in order to improve it. If you ask somebody to alter, it can change. So long as it does not change the entire document. Within the same document, it can make changes. So if you say A and B have not done it properly, can't I just remove them and replace them with some other things? That's the meaning. And the duty, it is a duty. It is a statutory duty. It is not a discretion.
The EC at the time argued that it was within a certain time.
Nobody bothered to find out what is the stipulated nomination period. Nobody. But everybody was talking. On the 30th, who said so? The law said that you appoint a day which will be for the nomination. It is that day that the papers will be brought to you. It is that day which is called the nomination day. And the EC told people that it will be available to accept their forms.
Exactly. Throughout
Ghana on the 29th and 30th. Is that a stipulated nomination?
So I was actually going to that because looking at the judge's ruling, it indicates, for instance, that the nomination days were the 29th and 30th. And based on his understanding, there should have been a period after the nomination day to allow these people to make the corrections, right?
That was my argument.
Good, and that's what the judge upheld.
Yes, but I'm saying to you that this is where you went wrong because
this is the argument put forward by the EC and other people. They said your client submitted the forms on the final day, and so they couldn't have made the necessary,
And the
you
point
couldn't have
I'm
gone through.
making
So
to you
I was
is
just
that
bringing that to you.
No
But that's the
problem,
point.
no
But again,
problem. But the
I had
point I
gone
am
on to your
making-
argument that you said, okay, so there should have been a period. There's a
So
distinction
I'm
between a
saying
nomination
that
and
did you
nomination
even find out? Those of you who were trumpeting that thing, Dr. Indum chose to go the last day and there was no opportunity. Did you find out whether the EC ever gave a nominated period? It was my argument that all she did was to say that candidates could come for the forms, whether parliamentary or presidential, on the 13th of September. And that was it. So in elections or electoral process, what we are talking about is opening of nomination. Before then, nobody can go to take a form. I says you can come and take the form from the 13th of September. So nominations have opened. When did she say that the nominations will close? Did you see it anywhere that for 13th to say 20th? That if you don't bring them by 20th, you are out.
I didn't see that. Did you see
Yes, that's what I said. These are my original arguments. So I'm only explaining to you. It's only that sometimes our judges also write without necessarily paying, if you like, referring to the arguments and saying that these are the arguments of counsel which I uphold. But because they are the judge, they say that this is what I find. But you look at the submissions that I made, and you will find that it was my original idea that, look, there was no stipulated nomination period because she only opened and never closed. Then at an IPAC meeting, she told them that, look, I'll receive the forms throughout Ghana on the 29th and 30th. Can you tell me whether anybody presented his or her forms before those 2 days? No. This would have been impossible for the simple reason that you've got to give the nomination forms to somebody called or designated a returning officer. The returning officer has a duty to perform. He must put the time that he received these things and the date on them. So it is not a matter of just going to any regional office, district office in your constituency or wherever. You see a returning officer, see somebody and say, I brought the forms before. Before what? And then to whom do you actually give this form? You've got to give it to the returning officer. So she created the problem. She never said...
But counsel for the Electoral Commission in that case argued that nothing prevented you from bringing it before the 2 days.
But that's the point I have made to you. When is the day? When? The day she nominated, she mentioned the nomination days. It is once you give, what I read to you, once you give your papers and they are received, plus your deposit, you become nominated. So where is the stipulated nomination period? Did she have one? The whole of us were sitting down, everybody was just talking. That's why I'm saying that before you move on, when things have happened, like all those letters that they were writing from, in the case of Nana Konadu, I didn't even bother to read because I knew that they were dead wrong. 29th and 30th, would it make a reasonable sense to you that the law says that when you give me the opportunity and I fail to take advantage, then you endorse that one and give it to the commission. And the commission is again given 7 days within which to take a final decision on the matter. He only tells you your nomination is invalid. He doesn't say that you are disqualified. Then he will transmit the record to the commission. And then the commission has 7 days under the law to take a final decision on the matter. So you cannot tell me that 29th and 30th were the same period and were the same nomination days. It doesn't make sense. It doesn't make sense.
So from everything, there should have been a period after the nomination days. There should have been a time within which these people would have been given a chance to effect the corrections or alterations necessary, and then they would have been given the go-ahead to contest the elections.
That was the context in which I said that you have a Farijan who is respected across Africa. He gives lectures on elections. He's been on the seat for a very long time. He's the immediate past chairperson. Why? He's done this thing all through. We've all known the opening and close of nomination and all that. Could have, maybe learned a thing or two from that individual. It's always dangerous when you take over without reading the notes and getting to know whoever you've taken over from, because there are times that you may need their, experience to bear. So this will show that there was clearly, some kind of, lacuna, which could easily have been filled if some of these people, and I was wondering, such, experienced election administrators like Amadou Sule has been there for some time. I would not be able to tell what the relationship is or what the internal working arrangements are. But otherwise, somebody like him should have been able to draw attention that, hey, madam, you have only announced an opening of nomination day, but you have not told us the close, and you've not given us the stated period. So all that, unfortunate things that were being said, that he could not have been given the opportunity because the nomination was closed. The nomination, I mean,
what does this mean for the PPP now? Yes, the court says they should have been given a chance. How does that happen?
Well, what it means is very simple. I mean, they were in court. They have a lawyer. They heard the judgment. This is the relief we sought. It's been granted. So tell them when they can come for the forms, because the forms are with them. Give the forms back to them. Let them go and effect the necessary amendments and alterations and bring them back. That's all. So it is the onus is now on the EC, because it is that onus which was cast upon them, that duty, that statutory duty imposed upon them, is what the judge is ordering them to now follow, which they could have done by just reading the law.
And so now they wouldn't have to go back and decide on a day and ask the PPP to come back, do the corrections and resubmit.
Keeping in view the fact that we don't have much time, because December 7th is across the corner. That's why everything was fast-tracked. We went to court, we filed our papers, we were asked to appear in court for abridgment of time. Time was abridged, and we were asked to file all our documents within a very short time, come and make the legal arguments, and thereafter we had a judgment. So within a week or so, I mean, I think that this thing has not taken more than 1 week, and we are through with it. So it should also keep in view the fact that we don't want to mess around with our 7th December date and do things, with some alacrity, so that, and finance, so that within a very short time we could get all these things ironed out.
Many have asked the question, and they've been wondering, can this affect the other cases?
Sure. I don't know what else. The EC Council raised the objection that, in his view, we needed to have come by way of election petition. I opposed it strongly, that it doesn't make one bit of sense. Election, petitions are used after an election. I'm saying that the election was invalid. I stand rather elected and not the person who has been declared a winner and all that. That is when you bring in an election petition. So if election petition is not the way to go, and I can clearly put my finger on, for example, the breach of the rules of natural justice, and then come to court by way of certiorari to have it quashed for me, that clears the way for all those who have not already gone. That, look, forget about this so-called animal which we cannot even define, we don't know its nature, called election petition, in the circumstance in which we find ourselves when we are talking about nomination, and then files a certiorari application to have the thing quashed on the same grounds that we went, basing your argument more on the fact that there was a breach of Regulation 9(2)(a) and (b), which offers an opportunity, especially 3, which offers an opportunity for 2(9)(a) and (b), which says that opportunity should be offered to the candidates to go and effect changes. If they should do that, I don't see how anybody will lose. And if they should all follow the same certiorari application format, it should be okay by going to issue a writ and adopting other modes of maybe invoking the judicial of the court, which might not augur well for some of them and may lead to delays.
Is that why you felt that they should have, probably seen you or brought the case together, and that would have made it easier?
Oh, no. Remember that these are political parties, and political parties, it is mind-lighted people, you know, people who think in a certain manner, you know, that congregate together in a political party. If I don't believe in your ideology, I cannot join your political party. So they may have their own, what you call it, friends. They may have their own legal advisors, you know, and the rest. So it will be the last thing for me to think about. Why? Who even knows that I may even win a case for them? They may not have. They have their own lawyers. They have confidence in those lawyers, like a doctor.
You were sure you're going to win the case, weren't you?
No, I was too sure because I looked at all the issues. It is so clear. I mean, breaches of, rules of natural justice. That's all serious matters. Once you breach them, you know, the consequences are clear. That your decision becomes null and void.
So it's a case of the Electoral Commission.
And when I said I was going to Supreme Court after the argument, what I meant was that there had been an earlier suit in which the people have complained about breach of the rules of natural justice, and the two earlier courts failed to quash them. The Supreme Court eventually quashed. And the Supreme Court said, why? You ought to have quashed them. From the evidence was so clear that you could quash them, but you didn't. So we are going to quash, and that was what I meant.
Okay.
That assuming that he had failed, I would have gone straight to the Supreme Court to quash, because that same ground of breaches of the rules of natural justice, you know, would be there, but it's not the first point of call. So you start from the High Court, then you can move on.
All right, so this is Hot Issues on TV3, and my guest this afternoon is former Attorney General Honorable Ayikoi Otoo, who was the lead counsel for the Progressive People's Party and the case where they challenged their disqualification by the Electoral Commission. And thanks for staying with us. I'm Winston Aman. This is Hot Issues on TV3, and this afternoon we're talking about the Progressive People's suit against the Electoral Commission and matters arising. We've been joined by the lead counsel, Honorable Ayikoi Otoo. So, Honorable, we're talking about the implications as we've established everything. But you had indicated that, I mean, if your case had failed at the High Court, you would have gone to the Supreme Court. What if the Electoral Commission decides to appeal against this?
On what grounds? That's the point. They wouldn't. I just do not see it. It won't happen. What I'm thinking she should be doing by now is to be holding a crunch meeting to decide the way forward. Call those who have all been disqualified and give them the opportunity in terms of the law so they could go and make the necessary amendments and alterations, bring them back, in time so we can move forward, because I do not see how. Look, there's something in law, in procedure, called amendments. You can always amend whatever you've sent to court if you find that the way it is will not achieve results. So having seen, and this judgment is all over. By the time we left the court, before we left, the judge told us that it was ready and we could have them. Already, you can find it on WhatsApp, social media.
I have read it.
I'm telling you. So what's the point? If you know the way you have gone is not proper, just do a recasting, amend A and B, and then you fall in line, and it will be well with you. So I don't expect her to think of going, on what grounds? We would have gone, as I said, on the same grounds of, breach of the rules of natural justice. That is the ground on which we would have gone again, that the judge ought to have quashed it. So although the court had jurisdiction and exercised that jurisdiction, within the same jurisdiction, she failed. He failed to see the point of quashing because there has been a breach of the rules of natural justice.
But I mean, some of these people have argued that High Court judges are not bound by the rulings of their colleague High Court judges, and so who knows? The others might just say that, well, based on the facts before them, maybe they wouldn't be able to argue the case like you did, and so based on the facts before them, they could say, well, you do not have a case, and that's the end of story.
No. If the ground is breach of the rules of natural justice, and they are able to put it to Regulation 9, they will succeed. Oh. That is all. That is all. You see, all the others are there. For example, Article 23 of the Constitution provides that administrative bodies, administrative officials are, to be fair to people that they deal with, and also, be bound by the laws setting them up. You understand? And now anybody who is aggrieved with that kind of decision can always come to court. So if, like I told you at the beginning, those who were making the earlier comments are not even since CI 94. They don't know what the provisions are. And yet they were running around with commentary, trying to vilify my client and others, which was most unfortunate. If those who are rushed to court, again, I know had time to look at the public elections regulations CI 94, and it's a wake-up call for them to look at it again. But because, as I said in Article 23, you just say that it was not fair to them. You collected their forms on the 30th, some on the 29th. They heard nothing from you until the 10th of October, when in the press conference you announced, have you worked according to your own law at, Regulation 9, 2A and B, which says if the forms have not been done in accordance with law, then to afford them opportunity to effect the necessary amendments and alterations. So I don't see which judge will say he doesn't appreciate this fact, because it is so fundamental. The rules of natural justice are so fundamental and germane to our, practice.
So the likes of the NDP that's gone to court on, a breach of the rules of natural justice, clearly, based on what has happened, they have a very good case.
All of them. You see, that is why sometimes, one shudders at the thought that maybe you plunge into a discussion and perhaps one is not too sure about the standing, the experience, and the appreciation of the person, the resource person. It becomes problematic. You see, you grow in the law, you mature in the law. You make your mistakes and improve upon them. Because like one of my colleagues who is now passed away, Stanley Amatefew, used to say, there's no res judicata against me as a lawyer. I went to court and I lost on this particular ground, and this is what the judge said. Next time you come with a similar case, I will use my authority against you. But at that time I lost. This time, when I use it against you, I win. There's no res judicata against me. So the more you do the cases, the more experience that you have, the more mature you become. And we have strategies and tactics in law. I mean, you don't have to put all your eggs in one basket if you think that, or show your hands too early, which will get bent. So you adopt some strategies and tactics. I'm not talking about any underhand tactics.
So in this case, what strategies and strategies do you adopt?
I'm saying that, look at the law. Do you need every ground? Do you need all the grounds? Excess of jurisdiction, lack of jurisdiction, so and so. Do you need all of them?
Tell me.
Perhaps the most germane could be breach of the rules of natural justice. And you may be okay. Or error apparent on the face of the record, and you may be okay. You understand? So that's what I mean by tactics and strategies. And then, for example, applying for certiorari, it's not the same as issuing a writ, or, if you like, going for enforcement of fundamental human rights. It could be something else, because it may have its own, mode of. So that's what I mean by tactics and strategies. So you look at everything and ask yourself which one can best achieve results. And look at this short period, we've been able to, finish this matter. And one of the rules of interpretation, presently under Section 10, I think 10.4 of the Interpretation Act, includes an interpretation which will lead to the improvement of the fundamental human rights and good governance. Could you imagine if anything had gone wrong and in the interpretation, how people would have taken it, and all these so-called people who are aggrieved, and you introduce tension into the country. You've got also to promote good governance, in whatever you do.
So I mean, those people who had gone to court with lots of reliefs, you'd advise that, you know, you could just go with a breach of fundamental human rights.
I've not even seen one. I've not even seen one, but I'm saying that when I go for certiorari, it's not the same as enforcement of fundamental human rights. It's different, and the mode may be different, you know. But you look at all the options open to you. Should I issue a writ? Can I go by way of, you know, prerogative writs? Should I talk about enforcement of fundamental human rights? You know, so the options are there. This is what I mean by strategies and tactics. Which one will best serve the interest of your client?
If these cases go on, could it affect the election date?
Likely, because you see, we want the world to see that the rule of law, you know, really works in this country. There's separation of powers. This is, once you go to court, it now goes to the remit of the judiciary. It is not for the executive to interfere and tell us what we should do, or for the legislature to say that, look, our time is up and we have to hand over. We have to, you know, close parliament and the rest, so you are delaying us. No, this is for the judiciary. And if you respect the law and the rule of law, then once the case is pending, you must give opportunity for the judges to look into the matter and come out with a decision. So clearly, I mean, this one affected the balloting for presidential positions. That is why they did the parliamentary one and not the presidential one. So that is one affection already. It's affected it. That's the way it has affected the elections. Because we've still not done the balloting for presidential positions. Okay. And so the more it stays, you know. And remember, the Supreme Court warned that we will not sit down for the EC to plunge this country into chaos.
And that could be the more reason why these cases will be dealt with, you know, quickly. Like your case, in about a week it was done, and then we moved on. And so to ensure that all things being equal, it doesn't get to affect the election date, because we can't go beyond 7th December. That's the last date constitutionally that we can vote.
Well, we can still go. We can still go.
Under what circumstances?
Remember that we're trying to push it forward to even November. I mean, court cases, you know, the orders of the court ought to be obeyed. So the court can make decision that, look, we've not finished this matter and we don't think you can hold the elections on the 7th. So we having an injunction placed on the election date.
But the Constitution says latest 1 month to the expiration of the term of the president, elections should be held.
The Constitution should develop. We should give an interpretation. We should look at the spirit of the Constitution. We should not read it like any other storybook. It's aspirations for the people of Ghana. It's the spirit which animates the Constitution, the need for rule of law, you know, separation of powers, good governance and things to be seen at work. So an interpretation could be given so as to, you know, make more room. You know, it's the way it is. Yes, 1 month, at least 1 month to the election, you should have, you know, 1 month to handing over. You should have had your elections, and then within 1 month and all that. But once cases run in court, they are bound to affect the timetable. So you look at how serious the case is and take a decision one way or the other quickly. Because you could work. You know, the problem in this country is that most people work morning to evening, and that's it. There are few people who do all night, you know, those we call essential workers. Basically, most people go work 9 or 8 to 5, and that's it. They're gone home. You go elsewhere, don't you see the shifts? You are working throughout. We should adopt it. Why should the courts close? Weekend. Nobody is sitting. Why?
Now, in the midst of all of this, would you say it was a blessing that, you know, Parliament did not amend the Constitution to allow us vote, or did not amend, you know, the bill to allow us vote on the 7th of November? Of
course, the minority did not give the requisite number. You know, the majority would have wished to. The minority said, no, we think you have too many problems, so why don't you take your time, you know, a bit and put your house in order. As we speak, I think they are now talking about preparing the register, giving the register out to the political parties.
Next week.
That has not even been done. And I ask yourself, under what circumstances somebody could have been, under what circumstance it could have been said that, look, you ought to know that the person nominating you was not qualified when I don't have the register, or his name has been put on another register when I don't have it. How am I going to go through it? But these are all issues. But you see, we are developing. We've gone through a few elections, 92, 6, 2000, 2004, 2008, 2012, 2016. We are developing, so with time.
Yes, but as much as we're developing, you'd agree that these are issues that should be dealt with before, we get into some of these things. Yes, we're developing, but clearly, a month to elections, that's when you're giving the final voters register. People have filed their nominations already. These things should have been given to them so they know those who are on the list before they file their nominations.
It's not the best. It is not the best. And who do you blame?
Tell me, who do you blame?
So if somebody advises the EC, for example, that you are an independent body and in the course of your work you cannot be directed to do anything.
That's a submission of the EC in court.
And you get this into your head. What do you think will happen to you? Then you become a law unto yourself, which is clearly not the position, because the Article 46, which grants you that independence, even tells you that subject to the Constitution itself. You are subject to the Constitution. So if the Constitution in Article 23 tells you that you should live within the law, okay? And tells you that you should exercise your discretion in a certain manner, a la Article 296, should not do it in a capricious manner, try to favor anybody, try to be fair. These things have all been stated in the Constitution, 2958. The fact that you are an independent body does not mean that nobody can take you to court to investigate as to whether or not you have acted in accordance with your own laws. Why should anybody create the impression that the EC is so independent that it's not subject to direction from anybody? Yet we've gone to court and we've seen the Supreme Court directing the EC that do ABC.
So that creates the impression the EC doesn't understand the very things it is expected to do?
Maybe it takes its independence too seriously.
Should it take it so seriously then?
No, if you do it to absurd limits, this is the difficulty that you find yourself in. The fact that you are independent does not mean that you don't work within laws.
Yes.
First of all, the law which set you up says that in order to implement and to execute your policies, you should always come out with a CI, a constitutional instrument in which you tell us how you are going to, execute your policies. So that's the first thing, which makes you a creator of statute, which tells you that you don't do anything without first putting it in a CI. That is why at the start, the PPP were shouting that where is the CI which has told us the modalities by which you are going to determine how much deposit should be paid. You remember that they were making that argument, that there ought to have been a separate CI which will show the modalities. But I said that if you read CI 94 as a whole, there is something there that they can tell, which provides that you pay a deposit as determined by the EC. But what they are saying is that it's not the provision which is important, but how do you propose to go out? How do you determine that somebody should pay 50,000? Somebody should pay 10,000. How do you determine that? What are the variables? What are the things that influence you to do or to say the things you say?
Okay. Well, Honorable Ayikoi Otoo, just hold on 1 minute for me, and thanks for staying with us. This is Hot Issues right here on TV3 with me, Winston Amwan. So, Honorable Ayikoi Otoo, going forward, there are those who say this could affect the image of the Electoral Commission. In recent times, they've been, seen by many as doing very well. Their confidence level is increased. Would you say that this would affect the confidence level that Ghanaians have in the Electoral Commission?
Everybody matures, as I've said previously. And so it's part of maturation. You make mistakes and you learn from the mistakes. once bitten, twice shy. So if your confidence levels become so high that you think you'll be on, is it cloud 9 or whatever, 7, or you think you can just do whatever, then of course the Greeks have said that those that the gods want to destroy first made mad and things like that. So you should be always careful, and also remember that no one person is a repository of knowledge. So you must begin to do wide consultations, and now with internet all over, you just can Google and see how a stipulated nomination period, for example, is set in other countries as against a nomination day or nomination days. And you can easily Google some of these things, which could be of assistance to you. So I would say that it's an unfortunate thing that has happened because it was too sweeping. I mean, it was like, is it a tsunami? That had hit so many people for the first time.
12 candidates.
Yeah, that they are all out, including very experienced ones who have been around before. Ask yourself. The law says thumbprint, and the person goes to make a mark. You think you cannot ask that same person who made the mark to go and put a thumbprint on it? Give him the opportunity to rectify this. Why should this lead to where we are, including very, very responsible political leaders being asked to make themselves available to the police to answer questions about forms that have been filled by their subordinates?
Because in this case, in this case, there were others that had this one person, subscribing for 2 presidential candidates using 2 different signatures. And so clearly the question is, how did that person use 2
Who determined the signatures?
The returning officer said those were 2 different signatures.
You see, you know everybody's signature.
The returning officer said she saw 2 different signatures.
You are not aware that one person can sign different signatures at the same time. When you are going to open a bank account, are you aware that they give you a signature form, to sign about 6 different signatures? Why do they do that? Because it can change. So who determined that? Who made a forensic scientist? Who made a handwriting expert to sit in the comfort of a house to determine that these are different signatures? Who said so? But that is why we should tread cautiously. Is it festina lente? Tread cautiously. What is this? What is the rush for? Then report the people to the police. They are not happy with her, surely. And if you say that this is what has happened now, is an issue of being demoralized, then of course you brought it up on yourself.
And so with this ruling, he has every right to get his name on the ballot. Correct.
Because why? Amend and alter. If I were advising him, I've told you, I'm MPP, I'm not PPP. So I don't know what they do in the closets, quietly when they go and meet. But if I were advising him, I'll tell him, take away this SIDA completely from the form. Go back to Buam, Jasikan district, and get a fresh individual. Come to Central Region, Kaswa, just across the border, Accra here, and get somebody in the Central Region, and so be it. Take away ASIDA. Don't leave that ASIDA on your paper anymore. That is an alteration. You alter, take him off, and get 2 new individuals to come.
Okay, Honorable Ayikoi, we need to be wrapping up, but finally, what will be your closing comments?
Although I'll call on the EC to tread very cautiously. I'll call on Amadou Sule, who has been there for some time, to bring his experience to also bear, and generally ask all the commissioners, as much as possible, take collective decisions, and they should consult and not rush in decisions which would, lead to what you call, their morality?
Confidence, lack of confidence in them.
Leading to lack of confidence and, affecting
and again, you bring in Amadou Sule. He should bring his experience to bear. And if I ask whether you're questioning the style of the Electoral Commission,
no, this is the last. You say I should tell you.
No, but your last word, you say you should bring his experience.
So I would even, yes, I will reinforce it. Don't we know that Madame Charlotte Say was a lawyer? He practiced. He went and did some corporate practice, became NCCE boss. And when was he appointed to the Electoral Commission?
2015.
Yes, so where's the experience? And thereafter, we're going to have elections, major elections. So that is why I say that people like Amadou Sule, who has been there, they have been in the trenches for some time, could always be there to assist, lend a helping hand. I am not running her down. That is a decision of the President of the Republic. She is the person, in her view, who was most qualified to do the work. That power to appoint remains with the President. He said, I've exercised that. This is the person I want. Understood? Does it mean that you cannot have advisors and others to assist you do the work? So we avoid some of these, if you like, avoidable pitfalls.
All right, so you heard from the lead counsel of the Progressive People's Party in their suit against the Electoral Commission. Well, they've been victorious, Honorable Lawyer Ayikoi Otoo, and I am Winston Amma. Thank you so much for joining us this afternoon on Hot Issues. Do enjoy your weekend.